40 years back in November 1984, 4,006 were killed in Delhi, the capital of India. The genocide continued unabated for 3 days. Every minute, one Sikh was killed on the streets of Delhi. After the genocide, the guilty were given high positions and they were given the position of power. For 40 years, the victims are still waiting for justice. The cases for the justice to the victims are still continuing even now. I, H.S. Fulka, a senior advocate, has been handling these cases right from November 1984 onwards. Through this video series, we have made an effort to bring to you how this massacre was planned. It's an effort to take you through the whole entire journey of this 14 years.
Hi everyone and welcome to today's episode. My name is Neetika Khaitan and I am a lawyer working on state repression, pursuing a PhD in history at Yale University in the United States. It is my pleasure to welcome senior advocate H.S. Fulka, who has worked on cases related to the 1984 anti-Sikh pogrom since the very beginning. Thank you so much, Fulka sir, for joining us. We had spoken in previous episodes about the first Judicial Commission of Inquiry set up to probe the violence, the Ranganath Mishra Commission. Despite its various recommendations, however, very little was done to bring the perpetrators of the violence to justice. What happened of the recommendations that the Mishra Commission had issued?
Mishra Commission had recommended 3 committees. Ascertain the total number of killings, because till 1987, it was not even known that how many citizens in the capital of India have been killed. The second committee to inquire about the role of the police officer, because Mishra had severely indicted the police for dereliction of duty and for connivance with the mobs. The third committee was that the FIRs were not properly lodged, the investigation was total perfunctory, and most of the cases by that time, in 1986, most of the cases, the final reports are already filed and the cases are already closed. So he recommended that a judicial officer and a police officer should be, a committee should be constituted of them, who will go into these allegations and into the registration of the cases. The government appointed M.L. Jain, Justice M.L. Jain, retired judge of Delhi High Court, and A.K. Banerjee, retired IPS officer. So this was Jain-Banerjee Committee. So it was in the month of September 87. This was appointed in 87, April 87. In the month of September 87, this Jain-Banerjee Committee recommended the registration of the case against Sajjan Kumar and other person, Brahmanath Gupta and others, on the basis of the affidavit of Anwar Kaur that Sajjan Kumar was leading the mob which killed her husband and other family members. Now, when this recommendation was given by the Jain-Banerjee Committee, a writ was filed in Delhi High Court. This was filed by Brahmanath Gupta, against whom there were allegations in many affidavits, against whom there were allegations even in Mishra Commission report itself of that he had even kidnapped a girl, young girl, and killed 9 members of his family. And on the petition of such a person, what Delhi High Court does, this came up before Justice Jogeshwar Tyar, the same judge who had earlier dismissed the PUTR writ petition. It came up before the same judge. He not only granted stay to this particular petitioner or other accused in this case. He granted a blanket stay, no case to be registered on the recommendation of this committee. And this was really shocking. So this brought the total working of the committee to standstill. Justice Yogeshwar Dayal was rewarded. He was made the Chief Justice. And after he went to other High Court as a Chief Justice, the matter came up before the bench of Justice S.B. Bhatt. Justice S.B. Bhatt on the first day, this was 6th May 1988. On the first day, Justice S.B. Bhatt said, forget about this committee. Forget about the recommendation of the committee. Here is the affidavit. This affidavit says that mob led by Sajjan Kumar killed my husband. He asked the government counsel, what justification you have not to register FIR on this? This discloses the cognizable offence. FIR has to be registered on this, even if there is no recommendation of the committee. The lawyer for Union of India somehow managed that give me 2 weeks time, I'll take instruction from the government, and the matter was adjourned to 20th of May 88. In the meantime, because Yogeshwar Dayal had gone, there was acting Chief Justice, Justice S.H. Chadha. Government tried with Justice S.H. Chadha to change the roster. Justice Chadha didn't agree. Now, Justice Narula, who was a retired Chief Justice, and he was also the member of Citizen Justice Committee. Justice Narula was father-in-law of Justice Chadha. Justice Narula has filed this affidavit before Nanavati Commission. And in this affidavit, he has disclosed everything. He said the pressure was put on Justice Chadha to change the roster and to shift this matter from Justice Bhatt. Justice Chadha didn't agree. So what the government does, matter is listed on 20th of May. 1 day prior, on 19th of May, they issue a notification bringing a new Chief Justice, Justice Pine from Calcutta High Court. Justice Pine take over on the same day morning, the day this case is listed. But on the 1 day earlier, he call up registrar and tell him that this case should be registered before me. So the case is registered before, listed before him, and the purpose for what he was brought, he simply adjourned the case. Justice Bhatt that day would have passed the order immediately and passed strictures against government for not registering a case on the basis of affidavit number court. Justice Pine simply adjourned the matter, and that carried on. It went to the bench of Justice B.N. Kirpal and Justice Chaudhary. Ultimately, on 18th, in 88, this is the judgment of 4th October 1989. 4th October 1989, they quashed this committee, Jain-Banerjee Committee, on the ground that the power to supervise the investigation cannot be delegated by the Lieutenant Governor. This power vests in the Lieutenant Governor. It cannot be delegated to another body. Now, this is the finding, but after that, there has been numerous cases where the SITs are appointed, where supervisory bodies are appointed, but unfortunately, as far as 84 is concerned, this is what they said, and they quashed this committee. You see, this period, after the Mishra report, between 87 and 89, this was a very difficult period. The Mishra had given a clean chit to the Congress party. The Mishra has given a clean chit to the Congress government, and the people had this in mind that the government has no role to play, as the Mishra has said. So it was very difficult to carry on this fight and to keep the issue alive. But we somehow managed, I along with Manoj Mitta, he was a young journalist at that time. We used to manage after every month or alternative month something or the other must come in the news so that issue is kept alive. We were waiting that when the election take place in 1989, if the opposition government comes in power, then at least we have some hope they will do something and give justice to the victims. In 1989, VP Singh government came in power. We had challenged this order of B.N. Karpal in the Supreme Court that SLP was pending. VP Singh government came in power, so we told VP Singh government that instead of waiting for the Supreme Court verdict, you appoint another committee in consonance with the judgment of Justice Karpal. Justice Karpal judgment says that it can be a recommendatory body, it cannot supervise the investigation and the police directly. So, another committee the VP Singh government appointed, they appointed as a recommendatory body that they will give recommendation to the Lieutenant Governor and Lieutenant Governor will pass the orders accordingly. So, Potti-Rosha, Justice Potti, retired Chief Justice of Gujarat High Court, and B.S. Rosha, retired Director General of Police, they were appointed into the committee to complete the leftover work of Justice M.L. Jain and Jain-Banerjee Committee. In the month of August, this committee also recommended registration of case on the basis of Anwar Kaur's affidavit. And they say this should be investigated by the CBI. CBI registered a case. On 11th of September 1990, CBI team goes to the house of Sajjan Kumar in the early morning to arrest him. When the CBI team is there, they were conducting the search and they arrested Sajjan Kumar. When they were bringing him out, a huge mob gathered all around. And the Delhi police was totally helping the Sajjan Kumar and the mobsters, because Delhi police was scared that if action start, then at least half of them, they would be, action would be taken against them also, because they were themselves involved. And H.K.L. Bhagat, who was a very powerful leader at that time, he thought that next turn is his turn. So they all got together. Delhi police didn't help the CBI team at all. The CBI team was kept at hostages. They didn't allow the team to take away Sajjan Kumar. The jeeps of the CBI team was burnt. Their ambassador car, that was window panes were broken. Now you can imagine CBI teams, jeeps and cars, they are burnt by the mob, and the police is a silent spectator. Now, in the meantime, what happens? This happened in the morning. From 8:30 onward, they have arrested Sajjan Kumar and they are kept there. At 10 o'clock, an oral application is made before the Chief Justice of Delhi High Court that the bail of Sajjan Kumar should be heard on urgent ground. It's an oral application. This application is being typed. Justice Pine is the Chief Justice. He immediately marked the matter to Justice M.K. Chawla. Even applications are still ready. That's also oral application before M.K. Chawla. He immediately directed that the Sajjan Kumar should be released on anticipatory bail. Now, Sajjan Kumar was already arrested. After the arrest of the Sajjan Kumar, there is no question of anticipatory bail. The High Court has no power to release him. It has to be produced before the magistrate. That's the procedure. And the magistrate will decide, then they can come in appeal or revision before the High Court. M.K. Chawla passed the order he should be released on bail and directed the registrar of Delhi High Court to call the CBI team at the house of Sajjan Kumar and direct him to release Sajjan Kumar. Look at this, what's happening. This is the High Court is doing this. And this incident was of 11 September. On 7 November 1990. 7 November 1919, he finally decided this bail and this is the final order. When he confirmed the anticipatory bail which was granted earlier, and he confirmed this order, Sajjan Kumar versus State, this is a petition, and in this petition, Justice Chawla in page 1, right? You see this here, that on 11th of September 1990, the anticipatory bail was granted and the registrar was told to telephonically inform the team of the CBI at the house of Sajjan Kumar. It's mentioned in the order. Then further, in para 4 and 5, he mentions that the jeeps and the cars of the CBI were burnt and the CBI team was kept at hostage. This is, when you see the influence of these people, even when this is the opposition government, you see that's what, and another episode I had said, this operation was not only by the Congress party, not only by them, this was by the deep state, by intelligence agencies. And the deep state protect its people. Deep state protects its operations, whichever government may be in power. Now the VP Singh government in power. And this is what's happening. Because of the reason, because intelligence agencies were totally behind these culprits and they were shielding them. So ultimately, Sajjan Kumar goes scot-free. So what happens then? This Potti-Rosha Committee's term came to an end in end of 1990. So Justice Potti was so much frustrated with this incident. He said there is no use of continuing. So he said, I don't want any extension. So another committee was appointed, Jain-Aggarwal Committee. This was Justice J.D. Jain and D.K. Aggarwal, the retired Director General of Police. That committee was appointed to complete the remaining work. So after the VP Singh, the Chandrasekhar government came in power. The Chandrasekhar government appointed Markandeya Singh as the Lieutenant Governor of Delhi. Markandeya Singh was a retired police officer. Markandeya Singh became, Chandrasekhar government also was very much interested that they wanted to do justice to the victims. Because Chandrasekhar was the one who took out the march, peace march on 2nd November 1984 to stop this violence. He was interested, his Home Minister Subodhkant Sahai was very much interested and the Lieutenant Governor Markandeya Singh was very much interested. So, Jain-Aggarwal Committee recommended registration of cases against H.K.L. Bhagat and against Sajjan Kumar. And they sent these recommendations to Markandeya Singh. Markandeya Singh immediately ordered the cases to be investigated by the CBI. Accepted the recommendation, case to be investigated by the CBI. In the meantime, Congress government had come in power. Narasimha Rao government had come in power. Bhagat write a representation to Markandeya Singh. I have been given clean sheet by Mishra Commission, though there was no clean sheet by Mishra Commission. I am given clean sheet by Mishra Commission and so I cannot be prosecuted. Markandeya Singh sent that letter of Bhagat to Justice Jain-Aggarwal Committee that you give your comment. Jain-Aggarwal Committee wrote back, there is no clean sheet and the wheels of criminal justice cannot be stopped. Cases have to be registered. Markandeya Singh directed the cases should be registered. That costed Markandeya Singh his post. Markandeya Singh was immediately removed as the Lieutenant Governor of Delhi. Look at at what level this is being done. He was removed as a Lieutenant Governor of Delhi. And after his removal, they sent 1 or 2 cases to CBI because Markandeya Singh, there was an order of LG and they took the report from the CBI that we are too busy, we cannot handle these, investigate these cases. Look at, the cases are being sent to the CBI and CBI refused to do it. The cases come back and there were total 21 cases which was recommended by Jain-Aggarwal Committee apart from others against the VIPs, against the leaders, Bhagat and Sajjan Kumar. 21 cases which were recommended by Jain-Aggarwal Committee, and in all those 21 cases, Markandeya Singh had accepted recommendation and directed to register these cases. These cases came and they were lying in Delhi police. This was from 1991. Delhi police didn't take any action at all on these cases. They were just lying in Delhi police, with Delhi police. In the meantime, in end of 1993, Madan Lal Khurana became the chief minister, and he formed a committee under the chairmanship of Justice Narula, and I was the secretary of that committee. That's what's called the Narula Committee, to advise the chief minister that what can be done for these cases. And he formed this committee. The members of this committee was Adarsh Goyal. That time he was a lawyer of Supreme Court. Later on, he became the judge of Supreme Court, and he became the chairman of the NGT, National Green Tribunal. He is recently retired. Adarsh Goyal was a member of our committee. Justice Narula was there, Adarsh Goyal was there, and I was there. Justice retired Judge Gupta was there, and retired Judge of Bombay High Court, Justice Lalit was there. He is father of Justice Juju Lalit, who recently retired as the Chief Justice of India. So they gave this report within a month, and we tell Madan Lal Khurana that these are cases which are lying with the Delhi police and action should be taken. Moment we gave this report, it came in the newspaper, the report. Immediately, the Home Ministry asked the Delhi police to send these affidavits to Home Ministry, so that they go out of the jurisdiction of Delhi police and Delhi government at all, totally. All the 21 cases were called by the Home Ministry. They were lying in the Home Ministry. Madan Lal Khurana wrote to the Home Minister that send it back. He met the Home Minister, sent these 21 cases back. Action has to be taken on this. Home Ministry refused to send it. Ultimately, Madan Lal Khurana held a press conference and said, I am going to Human Rights Commission against the central government that they are violating the human rights of these victims by not initiating cases on their affidavits. This is what in the Nanavati report. In Nanavati report, this is mentioned. This thing that Madan Lal Khurana threatened. This is mentioned at page 126. Madan Lal Khurana threatened to go to the Human Rights Commission against the central government. It's after that threat that the cases were sent to Delhi government. And the Khurana has said that when these files came back, and it was surprising, they were all jumbled up in a bundle. No, even the proper files were not made. As if this is junk, as if this is trash. Then Madan Lal Khurana followed that the cases should be registered. The cases were registered, but unfortunately, Madan Lal Khurana was not Chief Minister for very long. In the meantime, the Delhi police started totally protecting them. All these, when in one case I tell you, Harminder Kaur, her case was there against H.K.L. Bhagat. H.K.L. Bhagat was not asked even a single question. But Harminder Kaur was summoned in the police station. The victim, the widow, is summoned in the police station 6 times. 6 times. And her statement recorded. 6 statements they record, and they say, then because there is a difference in these statements, there is some contradiction in these statements. So therefore, case is not made out, file the closure report. This is the way they closed almost every case. Each and every case they closed in this manner. I will tell you in details. When Vajpayee government came into power, we got the case of the Harminder Kaur reopened, and the government directed the CBI to register the case and investigate it. But in the meantime, by that time, H.K.L. Bhagat was suffering from dementia. he was not totally mentally sound. So the case could not proceed against him, and soon thereafter he died. And as far as the other cases were concerned, sometimes you do something with a view to help the victims, but the government is so smart, they use it in their favor. This is what happened with us during VP Singh government. We asked the VP Singh government that you form a special court. The law minister, Goswami was the law minister. He said this is too tedious process to form a special court and you ask for exclusive courts. So they decided to form one court in that time there were only three courts, Tisajari, Patiala House and Karkadama. They say one exclusive judge will be assigned in all these three places to try these cases. So order was passed. These three special exclusive courts were appointed. But soon thereafter, when the Narasimha Rao government came in power, this Parthabaj was law minister. He used this opportunity. He brought a judge of his own choice, SS Bal, and that Bal's job was to finish all these cases. First, the Bal was given ultimately the charge of all three courts, all three exclusive courts. The Bal decided 123 cases, and out of those 121 cases, the Bal acquitted. The whole job was Bal was to somehow finish these all cases. Unfortunately, this is what happened. Almost the other cases during the tenure of the Bal, he almost finished these cases. Now, thereafter, in 2000, we again took up with the government. That time the Vajpayee government had come in power. We again took up the comment that these cases which were wrongly, now as far as these cases which were acquitted by the court, appeals were filed against them. That I will tell you about the appeals also. But as far as the acquittal cases are concerned, much could not be done other than filing the appeals. But as far as the cases which were closed by the police, large number of cases were closed by the police.
What happened to the other committees that the Mishra Commission had recommended?
Mishra Commission had recommended one is the committee to ascertain the number of killings. Ahuja was the Home Secretary at that time. The government appointed a Ahuja Committee to ascertain the total number of killings. Now that time the Delhi administration has given the number of 2,308. The CJC, we had given the list of 3,874. The police had given the list of 1,419. So that means according to the government figure of 2,300, the police did not have registered the cases of 900 killings at all. But then this Ahuja, after a long inquiry, he came out with the figure of 2,733. That though we don't agree with this figure, but this became the official figure after that. The other committee was to inquire about the role of the police. When that Kapoor-Mittal, a retired bureaucrat, she gave her report, she identified 72 police officers who are guilty either of dereliction of duty or of active connivance with the mob. Out of those 72, 32 she recommended are not worth keeping in service at all and they should be dismissed immediately. But unfortunately, no action was taken against any police officer. Inquiries was initiated. Ultimately, those inquiries was just an eyewash. Inquiries was finished. No police officer out of these 72 were punished. In fact, all of them has got promotions. Now, Seva Das, the DCP of East Delhi, where the maximum killing take place and who connived totally with the mob, the recommendation of Kapoor-Mittal Committee was that he should be dismissed. He got 3 promotions and he retired as Special Commissioner of Police, as number 2 in Delhi Police. Like that, each and every police officer got promotions and this. And you see one case recently which has come. In that case, the SHO of Kingsway Camp, Durgadas, inquiry was initiated against him. He obtained a stay from from CAT, and that stay was vacated a few years back. He filed a writ against that order, and he say, I am above 80 years now. This is 40 years old incident, so the proceeding should be dropped against me because of my age and because of the time lapse. This matter came up for hearing before the Chief Justice of Delhi High Court, Justice Satish Chandra Sharma. Justice Satish Chandra Sharma commented that as far as the justice to victim is concerned, the nation is still bleeding. It came up in the all newspapers. Justice Sharma commented, as far as the justice to the victims are concerned, the nation is still bleeding. Not it, you are 80 years, you may be 100 years. Whatever may be the time lapse, the victim deserved to be given justice and dismissed his petition. Now, this was a great relief to the victims to hear that today a day has come when the Chief Justice of Delhi High Court is saying this. There has been other questions also, some good judges, but this, the victims had seen that day when Yogeshwar Dayal kind of a passed orders of totally against the victim. Victim has seen those days when Justice Pine. Victim has seen those days when on oral application Sajjan Kumar is granted bail. When after this was quite heartening to see that to these remarks by the Chief Justice. Now Justice Sharma is a judge of Supreme Court now.
Thank you so much, Fulkaji, for this detailed summary of all of the various committees and commissions that were set up in the aftermath of the 1984 anti-Sikh pogrom to investigate the various happenings, and unfortunately, the little that was done to bring the alleged perpetrators to justice. Thank you so much for joining us for today's episode. And in future episodes, we'll cover more details of the cases that we referred to today. Thank you.